Disputes between tenants and their landlords are common, and they often come before NCAT. They're handled by the Tribunal's Consumer and Commercial Division and commonly relate to rental bond, repairs to the rental property, rent that hasn't been paid, or ending the tenancy. In the following scenario, Ling, a landlord, has taken her tenant to NCAT to try to get back 8 weeks of unpaid rent. The tenant is still living in the property, but Ling is experiencing financial hardship without the income that the rent provides. Ling was the owner of a 1-bedroom unit in inner Sydney that she rented out through a local real estate agent. Her tenant, Joshua, was 8 weeks behind in rent and refused to answer calls, emails and letters from the real estate agent. Ling tried to visit the property twice, but Joshua wasn't home. So Ling sent Joshua a termination notice to end their rental agreement. Ling then made an online application to NCAT to have Joshua evicted from the property for not paying his rent. She could have posted the application or given it in at the tribunal in person, but she chose to complete her application online because it saved her time. When NCAT received Ling's application, her case was listed for conciliation and a group list hearing. Conciliation is a process where the parties try to settle the dispute themselves in an informal way. It can avoid the need to go to a full hearing. A group list hearing is where a number of different cases are dealt with during the same session. The tribunal mailed Joshua a notice of hearing to tell him about the pending action against him. The notice was sent with a copy of the application form and a copy of his rental agreement, which Ling had provided as an attachment to her application. Ling was also sent a notice of hearing. Both Ling and Joshua's notices suggested they gathered together all the evidence they could to support their cases. In a tenancy dispute, this evidence might include rent receipts or other rent records, a report describing the condition of the property when the tenant first rented it, and any reports that may have been made since they moved in, a copy of the termination notice, copies of all letters and emails between the landlord or agent and the tenant, photographs, receipts for work done at the property while the tenant has been there, and witness statements or statutory declarations from other people who might have something relevant to say about the case. Joshua and Ling were told to bring all their evidence to the hearing in case they needed to refer to anything. They were also told that they did not need to bring witnesses. If they could organise their documents in a single folder, it would make it easier to find things during the hearing. Joshua and Ling were asked to arrive at the tribunal at least 15 minutes before the conciliation and hearing started to make sure they were ready when it began. Ling and Joshua were shown to the hearing room where their hearing was listed with a number of other cases in a group list. For this reason, there were other people sitting in the hearing room who had nothing to do with their case. Tribunal members are addressed by their surname, so the tribunal member asked parties to address her as Ms. Kim. The tribunal member asked Joshua and Ling to try conciliation before their hearing could take place. They were taken to an area outside the hearing room where they talked about the issues in dispute, showing each other their evidence and trying to negotiate a possible solution. Sometimes a tribunal conciliator is available to help the parties come to an agreement. The tribunal member explained that if they were able to reach an agreement during conciliation, then they should write it down on the conciliation form provided. They would then go back to the hearing room with their written draft of the agreement. The member would ask whether they understood the agreement and they were happy to sign it. If it was possible, the agreement would then be made into a legally binding consent order by the tribunal member. Unfortunately, Joshua and Ling could not reach an agreement on their own, and so the hearing went ahead on the same day. At the hearing, Ms. Kim explained what would happen at the hearing, that Ling, being the applicant, would be asked to speak first, followed by Joshua, who was referred to as the respondent. Ms. Kim said that she may ask some questions along the way, to make sure she fully understood what they were saying. She also explained that hearings are sound recorded. Ms. Kim found that Joshua was now 11 weeks behind in his rent. During his time to speak, Joshua said he was on a rent strike because Ling did not carry out repairs he'd asked for. But he also said that he had nowhere else to go and offered to pay Ling $50 per fortnight towards the rent that he owed. Ling said that she was having money problems because Joshua had not been paying his rent. Ms. Kim considered the evidence of both Ling and Joshua. She ordered that the tenancy agreement be terminated. This meant that Joshua would have to move out. If he refused to leave, Ling could obtain a warrant to take over the flat. The warrant is then taken to the sheriff's office. The sheriff could make Joshua leave. Joshua was also ordered to pay $3,800 in overdue rent and to give Ling a daily fee to stay in the unit until he left. If Joshua does not pay the money he owes, Ling can request a certified money order to lodge with the local court so she can recover that amount. Ms. Kim explained that a printed copy of the orders could be collected immediately after the hearing. Otherwise, they could be sent via email or posted within 5 days of the hearing. Ms. Kim also explained that decisions made by NCAT are legally binding. If you or someone you know has a tenancy-related problem that you cannot solve on your own, NCAT can help. Start by reading about NCAT services online at www.ncat.nsw.gov.au. Then you can make an application to have your case heard before the tribunal.